Honorable members, the House is at the Committee of the Whole House. We continue from where we stopped. That is on, we stopped at 239, supposed to go to 240. Am I right? Yes, that's part 2. Okay.
So part 2, case for the prosecution, clause 240, opening of case for prosecution.
It is proposed that clause 240, opening of case for prosecution, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 241, additional witnesses for prosecution.
It is proposed that clause 241, additional witnesses for prosecution, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 242, cross-examination of witnesses for the prosecution.
It is proposed that clause 242, cross-examination of witnesses for the prosecution, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 243, police statements and proof of statement.
Yes?
Saying is right. Sometimes, they write, statement for you and you cannot read it unless and until they explain it to you. And sometimes that does not happen at the station. They will not, in fact, they will not explain to you.
That clause 243, police statements and proof of statements, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 244, close of prosecution.
It is proposed that clause 244, close of prosecution, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. I don't know. I don't know. What he's making some observations, but we have already taken the. Yes, we have to rescind it if we choose to. is 244. Yes, you know the heading, close of prosecution. He was suggesting close of case of prosecution, something like that. Just like on 240. If you look at 240 for prosecution, yeah, closing of case for prosecution. Close of prosecution, I don't think it's wrong.
I'm not saying it's wrong.
So it is not. It is good as it is. So okay, 245.
Clause 245, no case submission.
The last sentence of the paragraph, there is forthwith acquit him or her. So we have to put or her there in addition. That's the whole sentence. If at the close of the evidence in support of the charge, and after hearing such summing up, submission or argument as the prosecutor or the accused person or his or her lawyer may wish to put forward, it appears to the court that a case is not made out against the accused person sufficiently to require him or her to make a defense, the court shall dismiss the case and shall forthwith acquit him or her.
It is proposed that clause 245, no case submission, stand part of the bill as amended. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Subpart 3, case for the defense. Clause 246, duty of a judge at close of prosecution's case.
It is proposed that clause 246, duty of a judge at the close of prosecution's case, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 247, procedure to be followed where accused is undefended.
It is proposed that clause 247, procedure to be followed where accused is undefended, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 248, additional witnesses for the defense.
It is proposed that clause 248, additional witnesses for the defense, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 249, evidence by prosecution in rebuttal.
It is proposed that clause 249, evidence. Kian West, you want to say something?
Yes, it reads, the accused person shall be allowed to examine any witness and shall, if he or she apprehends that a witness will not attend the trial voluntarily, apprehends. Let's look, if he or she apprehends that a witness will not attend the trial voluntarily. So is it accurate here? Yes, what I
The question now, it is proposed that clause 249, evidence by prosecution in rebuttal, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Subpart 4, close of hearing. Clause 250, summing up.
No problems? It is proposed that clause 250, summing up, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 251, subpart 5, passing sentence. Clause 251, calling upon the accused.
It is proposed that clause 251, calling upon the accused, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 252, motion in arrest of judgment.
No comments? It is proposed that clause 252, motion in arrest of judgment, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 253, sentence.
It is proposed that clause 253, sentence, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 254, power to reserve decision on question raised at trial.
It is proposed that clause 254, power to reserve decision on question raised at trial, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 255, objections cured by verdict.
The proposal is for us to remove the S. The usual these things, singular instead of plural. It is proposed that clause 255, objections cured by verdict, stand part of the bill as amended. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 256, evidence for arriving at a proper sentence.
It is proposed that clause 256, evidence for arriving at a proper sentence, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Part 8, clause 257, warrants to be issued in respect of sentences of imprisonment. Subpart 1, Parole. Clause 258. Court may direct release of prisoner before completion of sentence.
Yes. Mm, 258. It is proposed that clause 258, court may direct release of prisoner before completion of sentence stand part of the bill as amended. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 259. Levy on fine, etc. by distress.
This clause is making reference to clauses we've not yet reached. So I don't know what the committee has tried to remind us so that we can reconcile the two. Exactly.
Yes, levy of fine, etc., by distress. 1. Whenever a person has been ordered to pay any sum by way of fine, cost, compensation, or otherwise, the court making the order may, subject to the provisions of section 265, and in addition to any other powers conferred by section 263, take action to recover the sum by levying the same on the movable and immovable property of the person ordered to pay the same by distress and sale under a distress warrant. You mean the references?
Yes.
propose that clause 259. There are no amendments. Huh?
Propose the changes. Yes. I would rather say the following items shall not be seized under distress issued under this section, and then the A and B can come. Instead of just saying D, and then A and B, and then complete it below. I don't know whether it's clear what I'm trying to say. Yeah, it's much easier that way. It could be the following items shall not be seized under distress, under a distress issued under this section. That then you have the following items shall not be seized under a distress. Seized, S-E-I-Z-E-D, shall not be seized under a distress issued under this section. Then colon, you have A and B, finish. That is the items that are listed in A and B. Under a distress issued under this section. Because that's what they are trying to communicate here. They say D, A, B shall not be taken under distress issued under this section. When I brought this up. Yeah, sorry? Yeah, A and B remains the way they are.
It is proposed that clause 259, levy of fine, etc. by distress, stand part of the bill as amended. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 260, suspension of execution of sentence of imprisonment in default of fine, etc., and provision for the payment of installments.
You have nothing? Then you have something. He is suggesting that we remove S on installments. And no objections, AG. 260, the heading.
This one, I think this one is.
But why should this one take singular?
I think this one is fine. Because even
And provision for payment by installments. This, huh? We leave it as it is.
These cosmetic ones, S here and there.
Yes. Yes. Who?
Yes. Chairman,
Yes, nominated member, Keba.
yes, I believe this issue was raised earlier on by the Honorable Member for Larikunda Savage. But myself, I'm getting equally concerned now. The word etc. has been repetitively used in these clauses, so I don't know why. Maybe if AG can help us. You know, it is opening a lot of uncertainties in the law. You look at section 259, you'll find etc. there. You go to 260, you'll find etc. So, I mean,
Are you suggesting that it should not, etc. should not be used?
I'm not suggesting it. I want to know the intent of using it. Then after knowing that, we can decide whether to take it off or not.
Mr. Speaker, the drafters are saying this is acceptable where you start a list and it's not an exhaustive list. So you look at when they use it.
Yeah.
For example, here they started fine and they said extra. The extra could be cost compensation, could be or something else. So they started a list and they leave it open. And in that situation, they say it's very proper, you can use etc. Because the list is not exhaustive.
That's fine.
Because, yeah, so you know the rule of listing. If you list and conclude the list, it means anything not included in the list is not counted. So sometimes it's good to leave it open.
Yes.
And start it and say, it says there's any similar in this category. Because when you say fine, if you go to the paragraph itself below, you say when a person has been ordered only to pay a sum of money by way of fine, cost, compensation, and even there inside the clause they say otherwise. So we mean there may be other situations similar to this that are not capable of being mentioned now.
That's fine.
Chairman, can I comment? I think after listening to the definition of fine by the Honorable AG, it will be proper now to really eliminate the word etc. from it. No, because now, if you listen to the AG, he is telling you it can be fine, it can be cost, like the definition is there. And then it have given allowance for the addition of orders, which are not even listed.
Honorable, where is the definition?
AG just read it.
No, he never read the definition. He's giving you examples. There is no...
AG, can you just refer me to the section that you were reading? Then I can guide Honorable Chairperson. I can go there. It's section 259.1. I can read for you, Honorable Speaker.
No, I was looking at 260.
Okay, even 259.1, I can read for you. You'll find a list there.
But do you know that the title is only meant to guide? The substance is the clause itself.
Exactly.
Now that's what I'm saying. If you go to the clause have expanded it. The clause have given you a list. This is my argument now. If the clause is giving you a list, why do you maintain etc.? Honorable Chairman, my argument is...
Even the list itself is not exhaustive.
Which list are you talking about? Can you refer us to the list?
Now let's go to 259.1.
259.1.
The heading is saying levy of fine, etc. by distress. Now, if you read, it says whenever a person has been ordered to pay any sum by way of fine, cost, compensation, or otherwise. The explanation, Chairperson, let me learn. But just let me learn. That's what I'm saying here. Let me learn. The argument that was advanced by AG is ETC is used where a list is not exhaustive. So now I'm saying, if you look at the clause have given you that opportunity because it has started the listing from what cost, fine, compensation, or otherwise. Now that otherwise could have taken care of ETC on what? The heading. That's simply what I am saying. You don't need ETC if at all you are doing the definition inside the clause itself.
Chair, yeah, I think to allay the fear, it's not bad to have the etc. because 260 did indicate the list that is not exhaustive now because it put etc. now. Having that heading as a guideline, even if the text proper that explain it in detail has otherwise, does not also stop us from having etc. on the heading to tell you that it is not exhaustive. So they are even complementing each other in this text. So I think we are fine with that.
My only argument is using this ETC means you are uncertain of what you are doing, and we need to be certain.
Not really uncertain.
That's my understanding.
Yes, it's about list goes on, etc., etc. It could be anything.
Hey.
The clause 260.
So what's the conclusion? We leave it as like that.
Yes,
And we'll keep on using the etc.
when necessary.
And inside the definition, we'll maintain otherwise. When knowing that otherwise means that other things can be added. And we allow the... I don't understand, Honorable Speaker. I don't, honestly.
Say it loud.
Honorable Chair, if you will excuse me, here it is for us parliamentarians. AG will just give us guidance. But our comfort, our clarity and understanding is what matters the most.
Honestly, Honorable, there are two things. AG and others are just supporting us.
Thank you.
But they are the legal people. We cannot also leave the legal language and do it our own.
Now AG have guided us, and the guidance
when I'm talking,
we know that we can do without ATC.
Keba, when I'm talking, please listen. Please.
Chair, you don't allow members to speak.
No,
allow me to speak now, then you can make sense of what
Keba, if I don't allow you to speak, you will not be speaking.
No, you are cutting me loose.
Yes, that's my position now.
Okay.
I cut in when necessary. That's all. But I will let you speak until you finish. But it's mine now prerogative. When I feel that something is going this way, let me correct it. That's why I'm here.
Yeah, but I started an argument. Allow me to finish that. Then you can come up with something. Because I started something. Yes. Honorable Chair, can I bring in my argument first? Yes. Willie is.
Let's go ahead.
Chair, what I'm trying to say is, AG and the legal drafters are right in saying ETC can be used in legal drafting. But now it's the mind of the parliamentarians. If we are not comfortable with it, and for good reasons, I think we should. And we are saying that in the clause itself, there are provisions that can take care of others which are omitted in the listing. So why do we need it? The word otherwise is taking care of any other thing that is not being included.
Yes, we have now heard you well. I think that's what you are saying.
If you want to cut me, I can stop you.
The truth is, you are dealing with a legal document. We are not dealing with any other thing besides a legal document, mostly used even by lawyers. This document is mostly used by lawyers. So whatever we do, whatever we do with it, it has to take the legal trend. We cannot do it our own way, how we see it. All what we need is explanation. Is it legally correct? And what does it mean? And we get satisfied, we continue.
I'm sure you need to bear in mind interpretation of judges, how they interpret. That needs to be in our mind as well.
Yes, so, on the same issue?
Yes, on the same issue. No, this is 260. Yes, there is etc. also there. This the same issue. It's the same issue that I want to
say is your issue is on the usage of etc.
Exactly.
Okay.
Yes. So what I'm saying, if you look at the caption here, 260, suspension of execution of sentence of imprisonment in default of fine, etc., and provision for payment by installment. So if you look at sub 1, when a person has been ordered only to pay a sum of money by a way of fine, cost, compensation, and otherwise. So if we leave the etc. here on the caption, wouldn't there be any chance or a floodgate for to bring in other items that is already defined in other provisions?
The heading is supposed to define what the content is.
Yeah, but when you talk about etc., it's
no,
not
but
exhaustive.
in a heading, you cannot write, if for instance there are 40 here, you cannot put all those 40 in a heading when it will be detailed out. You just use 1, 2, and then the rest will come out later.
Chair, please.
Yes, Chair. And then you, yes.
Chair,
Right. Yes. Chair, the etc. here is talking about, only fine is mentioned in the heading. The etc. will take care of costs, compensation, and other matters. That's what the etc. is meant for. So let's understand it that way. It's as simple as that.
Chair.
It has to be in connection with this.
The same family.
Exactly.
Yes, go ahead.
Yeah, I think he has picked the very word from my mouth. That in fact, subclause 1 has even qualified more the heading. Exactly. That's why we need to have the etc. there. It's even qualified more the subheading.
I think we will not come back to this issue of etc. because as the honorable member said, we have dealt with it once, twice, and we are coming back on it. It is proposed that clause, where are we? 260, It is proposed that clause 260, suspension of execution of sentence of imprisonment in default of fine, etc., and provision for payment by installments, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 261, commitment for warrant of distress.
It is proposed that clause 261, commitment for warrant of distress, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 262, commitment in lieu of distress.
It is proposed that clause 262, commitment in lieu of distress, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. All misplaced references will be corrected.
Clause 263, warrant of arrest.
Let's read the warrant of arrest. Read it. Warrant of arrest.
Warrant of arrest. 1. A court which has ordered a person to pay a fine, costs, compensation, or any other sum, or against whom it has issued a warrant of distress, may at any time issue a warrant of arrest for that person if it is made to appear to the court that the person is making preparations to leave or is likely to leave the limits of its jurisdiction. Is it its or his or her jurisdiction? 2. Let me continue with 2. 2. Upon the person being brought before it, the court may examine the person and shall make such orders for his or her commitment or for his or her release upon recognitions as it considers fit. Yeah, I'm just talking about the last line of 1.
Limits of its jurisdiction.
Yeah, they are saying that the person is making preparations to leave or is likely to leave the limits of
the court's jurisdiction. The court's jurisdiction.
It's the court's jurisdiction they are talking about, not the person's jurisdiction. No, I'm following the language. Yes. Okay, and then the second one is the recognitions. Upon recognitions.
Yes.
1 recognitions for each case.
For his or her release upon recognition as it considers fit. The S should be out. Huh? We are in agreement. I think the S should be out. Huh? It is proposed that clause 263, warrant of arrest and part of the bill as amended. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 264, payment in full after commitment.
It is proposed that clause 264, Payment in full after commitment stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 265, part payment after commitment.
It is proposed that clause 265, part payment after commitment stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 266. Who may issue warrant?
You say what?
It's fine. I would have couched it a different way.
It is proposed that clause 266, who may issue warrants, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 267, limitation of imprisonment for non-payment of fine, etc. Clause 267. Oh, okay.
Right. A commitment, limitation of imprisonment for non-payment of fine, etc. A commitment for non-payment shall not exceed 6 months unless the law under which the conviction has taken place enjoins or allows a longer period.
It is proposed that clause 267, limitation of imprisonment for non-payment of fine, etc., stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Subpart 2, suspended sentence and community service. Clause 268, suspended sentence and community service.
Yes.
If you look at the caption, the spelling of service, the spelling of service is service. Yes, so that should be corrected. And in sub 3, we have problem with the term of imprisonment term. So sub 3.
I think you are going to read all because
I read the whole thing.
Yes, because otherwise we want to get the feeling
Yes.
to know what is being said so that we can make determination.
Yes. So suspended sentence and community service. 1. Notwithstanding the provision of any other law creating an offense, a court may order that the sentence it imposed on the convict, with or without conditions, be suspended, in which case the convict shall not be required to serve the sentence in accordance with the conditions of the suspension. 2. The court may, with or without conditions, sentence the convict to perform specific service in his or her community or such community or place as the court may direct. 3. A convict shall not be sentenced to suspended sentence or to community service for an offense involving the use of arms, offensive weapons. So we want to put S on that. Sexual offenses, or for an offense which the punishment exceeds imprisonment for a term of 3 years. Is 5. But
Weapons where?
in
Sub 3, third line, weapons. Offensive weapons.
Why are you adding your rule? You're departing from the rule?
No, this is not heading. This is not heading.
Yes, but the rule is not about the heading, it's about drafting in general.
No, but no. But sexual offenses. Why do you say sexual offense?
Sorry?
You are using plural. Offenses. You said the use of arms. You said it. Offensive weapons, therefore, sexual offenses.
The phrase is not use of arm, it is use of arms.
Yes.
Chair, let's remove all the S and leave them in their singular versions. Let's remove all the S's. Why no? You are saying that a single. No, Judge Babu. We just reconnaissance was in chair.
Hold on. What I would suggest is some of these legal issues, because it does not change anything. Just what is accepted that is what they do.
Chair.
Let's leave those things with the draftsmen.
Yes, Chair.
Draft people, so that they will either add as where necessary or make it singular.
The text here was changed from reconnaissance to reconnaissance. It wasn't a caption, it was a text. Yes, so why putting arms again on the text again, pull a version? No, sir.
You know,
I think your proposal is fine. Leave it to the draft.
The sentence continues. You know, it's saying involving the use of arms.
You know what I'm saying, Honorable?
And then he said offensive weapons
Honorable.
and sexual offenses.
Honorable.
So it has to flow.
Honorable. What I'm suggesting about these grammatical things like S and all these things, let's leave it to the draft.
Perfect.
Where they feel it should take the plural, let them make it plural.
But
where legally it should take the singular, let them make it singular for us.
You are the same person saying that it should not.
If we want to be doing this, we will make. Do we agree on that?
Yes, we agree, Chair. We agree on that. Let's allow the.
No, but we do not all agree. No, we do not all agree. We do not all agree.
Yes, somebody is. Yes. Who?
I just want also to be very careful. You taking the full stop, putting it there, removing everything is the work of Parliament. So we cannot give our work to the draftsman. I think we cannot take that route, Honorable.
No, that is not the work of Parliament.
No, of course.
Look, the work of Parliament is to make laws.
Exactly.
As per your own legal procedures and ways. Not by our own. What we are saying is, they are making this full stop where the full stop should be or where it should not be, or whether it should take S or not S. That's draftsman.
Change the meaning of the legislation, Honorable.
No. Because what we are made to understand is that if you use the singular, it can take care of the plural. This is what we are made to understand. So we have to use it and all that. That's professional, that's technical. We are saying that, let them do that. What's wrong about that? The honorable member for Kiang West, is it?
Honorable Chair, let's go. Willie is not making any amendment on this content, just the caption and S since we started.
Keep confusing us. You say it's the caption. No, this time it's the text. Chairman.
For 2684, if you see the sub ones is A, B, B. So we are saying that second B should be C. You've seen it? And then in the second line of C, you will see where they say hardened criminals. So we are recommending that instead of hardened criminals, we have habitual offenders or habitual criminals.
Chair, it doesn't make sense.
Yes, you asked me, I would propose we leave it as it is. Hardened criminals is much better than saying habitual offenders. You know? Yeah. Leave the word hardened criminals there. Listen to what it is saying. Honorable Chairman, let's try to look at the intent of this provision. It is saying prevent convicts who commit simple offenses from mixing them with hardened criminals. That makes more sense than saying habitual offenders.
Saying is prevent convicts who commit simple offenses from mixing with hardened criminals. Who are those hardened criminals? Is what we are.
Honorable Chair, can I come in? Thank you. That's a simple language we all understand. Hardened criminals?
Yes, I want to. I want to support the submission. I don't want to. Kewa, yes.
What I'm saying is, it's better for us to leave it as it is. As it is, yes.
Yes.
Absolutely.
Yes. Honorable Speaker, yes, I want to support this proposal, not to use these habitual offenders. They are trying to do prevention here, or safeguards, not to mix those simple offenders with hardcore criminals. Armed robbers, I'm sorry to say that, but big hardcore criminals who have been languishing in prison for long. So we leave it as it is. Yes. Thank you.
Chair, I just want to suggest that we make we add something onto that, looking at section 2683. 3. To just, not just to limit it with hardened criminals, but to have their list. For example, sexual offenders, armed robbers, you name it.
But if you name them, it's not exhaustive. You cannot name all of them. This is the problem in naming. When you name one, then it can mean those types. You know. But you want to name all of them, it may not be exhaustive. Yes. No, but let's get his point out clear first. What his concern is we name. Okay. Yes. Kiam West.
Yes, Honorable Chair. 4, sub 4.
You are bringing something different, eh?
Sub 4, yeah.
Yeah.
Sub 4, it's the court in exercising its power under subsection 102. And I'm trying to look at it to say the court in exercising its powers under subsection 102 shall have regard to the, yes. It cited 2 sub-clauses, shall have its powers, because there is a power that is conferred on the courts under these 2 clauses. Billy, you have not gone to legal school, you. Sometimes this is logic. You don't need to go to bar to know this. I need clarification here, because there is a power that is conferred on the court under subsection 1 and also under subsection 2.
So, for 268, the only correction is weapons will have an S on 3, and then the numbering of 4, A, B, B should be 4A, 4B, and C. These are the corrections we have.
Honorable Chair.
Just a minute. These are the corrections we have so far. Are you going to define that?
Honorable Chair.
What he is suggesting, AG, is in this particular C, 4C, now, that's hardened criminals. He said we define hardened criminals. He's suggesting that we define it.
We are doing criminal law. There are certain terms that are notorious in criminal law. You don't necessarily have to give the textual definition. But off record, and I see this plural term being defined, I refer you to Clause 3 of the Interpretation Act. That's where the answer is, this plural singular. It says, unless a contrary intention appears, words in a singular includes plural, and words in plural include singular. This is contained in our Interpretation Act. There is an act specifically for interpretation of laws called the Interpretation of Act. In that act, it says whenever a legislation uses singular, it could mean plural, and when it uses plural, it would also include singular. So I think for now, from now on, you should do away with that debate now. You know, you understand that there is a law that takes care of some of these, small issues in our legislations, and it's called the Interpretation Act.
Members, honorable members, we have corrected the weapons to S, isn't it? Or we are now ignoring it? We are ignoring it. So we are ignoring all those S and these things. Now the only this thing is the changing of the second B to C. Huh? Yeah, huh? Which service?
Community service.
Yes. Community service. The spelling of that service. Capital service. Please propose that clause 268, suspended sentence and community service, stand part of the bill as amended. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 269, arrangement for community service. Arrangements for community service.
You have something?
Yeah. Yes, Chair, 269 3B. You've seen it. Providing assistance to the court in arriving at an appropriate community service. At 3B. B. In arriving at appropriate community service. It's our suggestion that we put an before, after at an appropriate community service order in each case. Yes. And then and 8, sub 8, line 3. It says, upon sentence to community service, a convict shall be required to produce a guarantor who shall undertake to produce the convict if he or she absconds. But what is there? If the he. So we remove the article D before the he. And then we add or she before absconds. Yes, absconds.
No, Chair, I think that one is also settled. They say he can be she can be he. So no correction there.
Well, we are using his.
No, it's settled.
It is proposed that Clause 269, arrangements for community service, stand part of the bill as amended. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
This is the last amendment of from the committee. Yes.
Clause 270, performance of community service order.
It is proposed that Clause 270, performance of community service order, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 271, default of convict in complying with community service order.
It is proposed that Clause 271, default of convict in complying with community service order, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 272, commission of further offense.
It is proposed that Clause 272, commission of further offense, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 273, amendment, review, and discharge of community service.
Any? No issue. It is proposed that Clause 273, amendment, review, and discharge of community service, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 274, discharge of community service order.
It is proposed. It is proposed that Clause 274, discharge of community service order, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Subpart 3, police supervision. Clause 275, person twice convicted may be subject to police supervision.
Yes, Chair. Person twice convicted may be subject to police supervision. 1. When a person having been convicted of an offense punishable with imprisonment for a term of 3 years or more is again convicted of an offense punishable with imprisonment for a similar term, the court may, at the time of passing sentence of imprisonment on that person, also order that he or she shall be subject to police supervision under this act for a period not exceeding 5 years from the date of his or her release from prison. If the conviction is set aside on appeal or otherwise, the order shall become void.
Yes, Honorable Member for Kiang West.
Yes, but here it is saying convict of an offense twice. But what kind of an offense convict of?
That Clause 275, person twice convicted may be subject to police supervision, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 276, requirements from persons subject to police supervision.
Requirement from persons subject to police supervision. 1. A court may at any time direct that a person shall, while subject to police supervision under this act and at large in the Gambia, comply with all or any of the following requirements and may vary any such directions at any time. A. To reside within the limits of a specified area. B. Not to transfer his or her residence to another area without the written consent of an authorized police officer in charge of that area. C. Not to leave the area in which the person resides without the written consent of the police officer in charge of that area. D. At all times to keep the authorized police officer in charge of the area in which the person resides, notified of the house or place in which he or she resides, and provide his or her telephone and other contacts. E. To present him or herself whenever called upon by the authorized police officer in charge of the area in which the person resides at any place in that area specified by that officer. 3. The Attorney General may make regulations for carrying out the provisions of this section, and in particular prescribing the manner in which persons may be brought before a court for the purposes of this section.
The numbering 1 and 2 instead of 3 on that sub 276. Yes, that's all.
Sorry, I apologize. What I was trying to discuss with others is that under A, to reside within the limits of a specified area. You know, this man he was a convict who has serviced his term imprisonment. He's out. Now he's under surveillance. You are limiting the person's movement.
I try to understand why I think the explanation is.
Honorable Chairperson, I don't think all of these conditions are a must in any given. The situations might differ because if you look at 1, it says a court may at any time direct that a person shall, while subject to police supervision under this act and at large in the Gambia, comply with all or any of the following requirements and may vary any such directions at any time. So it depends on the situations. But if you ask me, I would say to limit the individual to stay in a specified area might be needed in certain instances, depending on the situation. But that is very, very normal. But it doesn't mean all of these conditions will apply. Yes. What is he being punished for, Honorable Chair? Honorable Chair, Honorable Chair, if you look at section 275, look at section 275. That's where it starts. Okay. Sorry, Honorable Chair, you are in 276. Look at section 275. It says that persons twice convicted may be subject to police supervision. So there's a condition attached to it.
He has served his sentence, he is out. Now, you giving people the option to restrict that person at one area only. What I'm trying to say, so far is within the jurisdiction of the Gambia. If the police supervision can continue, even if he moves from here to NBR, the police, you can transfer these things to that place, so that he can move and be under supervision. But if under that condition, you cannot travel outside the Gambia. Yes? No, you can be, yes.
But what is...
There is nothing to justify that. Emotionally. because I ask myself, why can't he travel outside? I have no answer.
That is one problem. There must be a reason. I said the A is a problem because if the person has a compound in a particular place and that's where he or she can reside, but then the officer or officers do not want him to reside there, they want him to reside somewhere, and they are not going to pay for him or her, that's going to be a problem. You understand what I'm saying? So the other thing is that how long will they play surveillance on the person? Because up to 5 years.
If we are in Woolly, it can happen. So why do you restrict him from moving? Let's ask the AG.
Honorable Speaker. Yeah, Honorable nominated member have tried to explain, but we missed a point. A, restricting the movement to a given geographical area or specified area is just one of the tools in the tools box. It may not even be used, but where necessary it will be used. But what you are saying is also provided for if you look at the rest. The issue of when the person has freedom of movement, when he moves from one police region to another police region, the police officer in charge of him will hand over to the other police officer on that. All those things are in the toolbox. But A is also just one of the tools, and it may be necessary. Some of these criminals may be so dangerous that the court might deem it necessary to restrict their movement, at least temporarily, for them to be properly supervised. If that is determined by the court that it is necessary, it might impose it.
So what we are saying is, what are those situations where somebody who is no more a criminal, he has serviced his time in these things, he is now a free man.
himself or herself from committing that crime, maybe you can use this one to take the person away from that area. That's what I'm thinking.
No, but that's not a good example. Take a real situation, because this drug is done everywhere. That one is not good enough. So give us one that is real, that one can see where a situation like that would happen.
For example, if the person is, for example, troubling a particular family, causing trouble to a particular family in the same area, and twice she has been doing that. Now, if you want to stop that problem, it's like you move the person from that area to go to a certain area, to be away from them, so that he can stop the trouble that he or she is causing.
So what we are saying is, there are certain things we can leave it to people to make determinations. But there are certain things we have to make those determinations. If we think we are convinced enough, then fine. Fine. But while I'm looking at a situation, this person is not a criminal. He has served it. He is a free man like you and I. But because of the fact that he has committed it twice, we said we should observe him to see what he is doing, to probably prevent a recurrence. Yes. In doing that, it's fine. But if he is moving, if he is in Serekunda, he wants to go to LRR, allow him go there, let the surveillance move to LRR. Yes, let's have Sami and then we come back.
Thank you very much, Chair, for giving me the floor. Honorable Chair, if at all is somebody who is habitual doing armed robbery and he was sentenced for a particular year and that year elapsed, that person's movement should be monitored. It should be monitored. Yes, he should be restricted. If not, he's going to do the same thing. He should be restricted.
Honorable Speaker, we've been checking. We reference Ghana's laws and Kenya, but I also checked even the UK. These issues of former convicts being put under supervision can include different methods depending on the threat level. There are situations where they even restrict their movements in certain hours. You have to remain in your house in certain hours, you don't go out. There are times where they exclude them from going to certain areas, like you said. But there are times that they also limit their movement only within a given area as well. So the courts will evaluate the level of the threat, and the state will have made a case to the court, depending on the kind of crime the person was involved in, and the necessary. This is all for protecting the public.
It looks like all the argument you still believe that it should be there.
Oh yes, definitely yes.
Yes, thank you very much, Honorable. I'm not okay with it, and until I give my position. Right now, what I'm asking myself is why police supervision? Somebody has committed a crime. The state arraigned the person before a court of competent jurisdiction and sentenced the person twice. Do you understand? So, Attorney General, are you not breaking that principle of law, double jeopardy? That is punishing somebody for twice for a particular crime. Because for me, to the extent of even telling him you should not go out this particular time, you should live in a particular, you stay in prison, literally. And it's the same crime the person has committed. So for me, if you ask me, this law is not progressive, we need to get this police supervision out.
In fact, this is novel, to the contrary. You see, public safety overrides individual rights.
Yeah.
If an individual is a threat to the public, that is why we have prisons. So if you continues to be a threat, like you committed a crime, you are punished. You committed a crime, you are punished. And it is determined that your continuous freedom continues to pose a threat to the public. This is the kind of situation. This can include repeated sex offenders. It could include terrorists who you don't have to wait until they strike. You have to control them before they strike. So there are certain kind of criminals, when they strike, it's too late.
Yeah.
So it's important the state to have them under surveillance before they strike.
In fact, Chairman.
Honorable, we have had enough. The pros and cons and all these things. So that's why we want you are pros. Yes. So now, honorable members, I think those who want it to remain are in the majority. Do you still want me to put it to a vote? I don't think it's necessary. It is proposed that clause 276, requirements from persons subject to police supervision, stand part of the bill as amended. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 277, automatic police supervision.
That clause 277, automatic police supervision, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 278, failure to comply with the requirements under section 276 or 277.
Any comments? It is proposed that clause 278, failure to comply with requirements under section 276 or 277, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Subpart 4, probation of offenders. Clause 279, power to admonish and release.
It is proposed that clause 279, power to admonish and release, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 280, power to release upon probation instead of sentencing to punishment.
It is proposed that clause 280, power to release upon probation instead of sentencing to punishment, stand part of the bill. Are we comfortable with 280? Youths, are you comfortable? All right, we continue. Go. Didn't I put it? I put it. All right. Power to clause 280. Power to release upon probation instead of sentencing to punishment. Stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
281, probation order.
It is proposed that clause 281, probation order, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
282, costs, damages, and compensation.
It is proposed that clause 282, costs, damages, and compensation stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 283, commission of further offences by probationers.
It is proposed that clause 283, commission of further offences by probationers, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 284, probation order, disqualification, or disability.
It is proposed that clause 284, probation order, disqualification, or disability stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 285, contribution towards expenses of residence at a probation home.
It is proposed that clause 285, contribution towards expenses of residents at a probation home, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 286, transmission of documents when case is remitted to another court.
This was what the Honorable Minister was saying. Huh? Yeah, let's see what is contained there, whether it will help in the speedy listing. Where an offender, go ahead.
Where an offender is committed to custody or released on bail by a magistrate or children's court until the offender can be brought or appear before the court, which made the probation order or order for conditional discharge. The magistrate or children's court shall transmit to the other court the particulars of the case that it considers desirable. 2. Where the offender is convicted of a subsequent offense by a magistrate or children's court, that court shall transmit to the other court a signed certificate to that effect, and for the purposes of the proceedings in the court, which transmitted the certificate, if purporting to be so signed, is admissible as evidence of the conviction.
Some differences, yeah. All right. Clause 286, transmission of documents when case is remitted to another court. Yes?
I want to be very sure here. The last two sentences of sub 1, where the magistrate or children's court shall transmit to the other court the particulars of the case that it considers desirable. Yes, I want to be sure, Egi, part of the case that the court thinks desirable, or the court is under obligation to transmit every fact about that case, that particular case, to the other court, or the court will decide which one is desirable and which one is not desirable. Why do we have this word there that the court considers desirable? I don't understand that. Because transmitting, you have to transmit everything.
Chair, let's close. The Kiankas are fighting. Hey. Chair, it's a good time to close. It's a good time to close. You are seeing the Kiankas fighting, you are saying no, no, no.
Waiting on you.
We have the option of eliminating the ambiguity by putting a full stop after the case. Option of eliminating the ambiguity by putting a full stop after the case. That extra discretion we are creating is causing a bit of a confusion. That it considers desirable may be confusing.
Yeah. Yes, that's okay.
Full stop at case on 286.1, the last line, that it considers desirable is out. It is proposed that clause 286, transmission of documents when case is remitted to another court, stand part of the bill as amended. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 287, amendment of probation orders.
It is proposed that clause 287, amendment of probation orders, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 288, discharge of probation orders.
It is proposed that clause 288, discharge of probation orders, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 289, transmission of copies of order for amendment of discharge of probation orders.
It is proposed that clause 289, transmission of copies of order for amendment of discharge or probation orders, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 190, selection of probation officers. Clause 290, selection of probation selection of probation officers.
It is proposed that clause 290, selection of probation officers, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 291, probation institutions.
It is proposed that clause 291, probation institutions, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 292, appointment of probation officers.
It is proposed that clause 292, appointment of probation officers, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 293, regulations.
It is proposed that clause 293, regulations, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 294, delegation of powers.
It is proposed that clause 294, delegation of powers, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 295, contribution towards expenses of residents at a probation home.
It is proposed that clause 295, contribution towards expenses of residents at a probation home, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Subpart 5, trial of a corporation. Clause 296, interpretation under this subpart.
It is proposed that clause 296, interpretation under this subpart, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 297, appearance by a corporation.
It is proposed that clause 297, appearance by a corporation, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 298, plea by corporation.
It is proposed that clause 298, plea by corporation, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 299, information against the corporation.
It is proposed that clause 299, information against a corporation, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 300, joinder of offenses in same information.
It is proposed that clause 300, joinder of offenses in same information, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 301, power of representative of a corporation.
It is proposed that clause 301, power of representative of a corporation, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 302, matters to be read, said, or explained to representative.
It is proposed that clause 302, matters to be read, said, or explained to representative, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 303, non-appearance of representative.
It is proposed that clause 303, non-appearance of representative, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 304, saving under this subpart and joint charge against corporation and individual.
It is proposed that clause 304, saving under this subpart and joint charge against corporation and individuals stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Subpart 6, defects in order or warrant. Clause 305, errors and omissions in orders and warrants.
It is proposed that clause 305, errors and omissions in orders and warrants stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Part 9, appeals. Subpart 1, appeals from subordinate courts. Clause 306, appeal to High Court.
It is proposed that clause 306, appeal to High Court, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 307, no appeal on plea of guilty.
It is proposed that clause 307, no appeal on plea of guilty, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 308, right of appeal against acquittal or dismissal.
It is proposed that clause 308, right of appeal against acquittal or dismissal, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 309, limitation of appeal.
It is proposed. This one, take your time. Which one? This.
Limitation of appeal.
An appeal shall be entered within 30 days of the order or sentence appealed against. An appeal shall be entered within 30 days of the order or sentence appealed against.
This has been a very, 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 very old standard, really. This 1 month appeal has been here forever, pretty much. So I think we just maintained it. Some jurisdictions have even shorter. Some will go 21 days, some 28 days. Sorry? When a decision, a verdict is delivered, you inform both parties right there and then that you are entitled to appeal within this period. So the issue of ignorance is no longer applicable. Practice, Honorable Speaker, the lapse of the time by practice in the courts, if the defendant can make a strong case, normally courts allow them to accept their appeal. They can extend the time for them and allow the appeal. But you have to make a strong case for it.
But why don't you have a provision? Because where you cannot extend the time, then let's say if somebody is 1 month and somebody is 45 days.
Discretion to the court to extend the time. We can leave the 30 days.
No, what I'm saying is, yes.
And then we say, when the courts have discretion to extend it, probably for additional 15 days where applicable. This is a period where the court can exercise its discretion. If the delay is justified, it can allow the appeal. No, the court will know. The court will know. If you are given 30 days, the 30 days lapse, you know you've not filed it. You are already out of time. Now, if we allow the court to reconsider you even after 45 days, for example, on the 45th day you file in your notice of appeal, right? The courts don't reject it at filing. No, they will hear it, they will assign it to a judge, and the other side will be served. And it is when they appear now, assuming you are out of time, it is for the other side to argue, to tell the judge that this appeal is incompetent because it has been filed out of time. Right? Now, that is when now you probably, while you are filing your notice of appeal in your affidavit, you would have informed the court that, yes, I understand I'm out of time, but these are my reasons. And then the court will look into your reasons. If they are good enough, the court can use its discretion and say, you are only assuming that, Honorable Speaker, let me correct something. You are assuming that it's only somebody who is convicted is the one that is appealing. All right? Sometimes we appeal the states. People are acquitted and we are not happy we appeal against the acquittal. Okay. Let me tell you the equivalent. The equivalent, for example, in the civil proceedings. In the civil cases, for instance, if you are served with a writ, somebody summons you, the court, the rules say you must file your defense within 30 days. Okay? If you know by the 30th day you are not going to be able to file your defense, you have to file a motion applying for an extension of time. So you have to do that within the 30 days given to you. You don't wait until the 30 days lapse, you now come to apply for extension of time. Within the 30 days given to you, if you know you can't make it, you will have to file a motion asking for an enlargement of time. Now, that enlargement of time too is limited to not more than additional 2 months. Yeah.
Necessary. You can do it yourself. How can you put a motion yourself? An ordinary person from Alberta can make that motion. Huh? How can we make that motion? You have to go to a lawyer and you have to give him something. This is where we are running away from. They are aware that they want to appeal. They want to appeal because they are convinced that they have been.
Let me tell you how the convicts.
Let me just ask you.
So you are very sympathetic to the convicts. Let me help you, sir.
No, let me just ask you one question. Is it possible, or has it ever happened, that where the time of 1 month appeal has elapsed, and somebody's appeal has been entertained? Huh?
We do accommodate appeals. But let me even give you how they handle this. If it is about the convicts that you are very much worried, especially those that are in prison, the prison authorities always remind them as well. And remember, they are there with other prisoners who are experienced. But the prison authorities tell them, within the 30 days, normally, the prison authorities help them to complete the notice of appeal, even if just a 1 sheet of paper. Once they file it, the issue of time does not affect them anymore. And that can be there. They have now taken care of the time issue while they are looking for counsel or doing other things. So they can file a notice of appeal, which is normally is a sheet of paper. It's provided to them even in prison. The prison wardens or they themselves can help them to fill it. And then normally it's not in the perfect shape, but they file it. Once they file it, they have beaten the issue of time. And then when they get a counsel, the counsel can now regularize that by properly amending the notice of appeal and giving the proper grounds.
Okay.
Before you move,
Where is it? We are 309. It is proposed that clause 309, limitation for appeal, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 310, petition of appeal.
It is proposed that clause 310, petition of appeal, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Honorable Speaker, look at clause 311. If you look at clause 311, those that are in prison, the prison authorities are required to even support them. No, we are not yet there, but I'm calling your attention to it to say, we are already there. Yeah, okay.
Appellant in prison.
It is proposed that clause 311, appellant in prison, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 312, summary dismissal of appeal.
It is proposed that clause 312, summary dismissal of appeal, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. Huh? You've read it. Summary dismissal.
Clause. You put it. Huh? You put it. Clause 313. Notice of time and place of hearing.
It is proposed that clause 313, notice of time and place of hearing, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 314, power of High Court on appeal.
It is proposed that clause 314, power of High Court on appeal, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 315, order of High Court to be certified to lower court.
It is proposed that clause 315, order of High Court to be certified to lower court, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 316, suspension of executions of appeals.
It is proposed that clause 316, suspension of executions of appeals, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 317, further evidence.
This
When the appellant is ultimately sentenced to imprisonment, the time during which he or she is so released shall be excluded in completing the terms for which he is sentenced. So I thought that that should be reduced from the term.
If the person was granted post-conviction bail, bail pending appeal. If he was on bail pending appeal, the period that he has been out will not be credited. Yeah, it's only counted when you are under custody.
we have taken care of those ones. We said these people would do those things.
Where is it? Just let him highlight it so that we can.
Yeah, it is there.
Is when you are convicted and sentenced, there are two categories. You can be appealing while you are serving the sentence. If the appeal confirms your conviction, then the time that you have served as at the date the appeal verdict came would of course naturally be credited. So you only complete what is left. But this is addressing a situation where you have been granted bail pending the appeal.
It is proposed that clause 317, further evidence, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 318, abatement of appeals.
It is proposed that clause 318, abatement of appeals, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 319, second appeals.
It is proposed that clause 319, second appeals, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 320, limitation and general.
It is that clause 320, limitation and general, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. The House now resumes, sir. I hope. Honorable members, the House now commences. We were unable to complete the consideration stage of the Criminal Procedures Bill, but it will be rescheduled to another time when we will try to consider them to finish it next time. Meanwhile, I now put the question. Be resolved that this Honorable Assembly do stand adjourned until Wednesday, 12th March 2025. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. This Assembly now stands adjourned until Wednesday, 12th March 2025 at 10 a.m. prompt.